Okay, so good morning, everyone, and thank you for joining the Burness Paul Junior Energy In-House Lawyer webinar series. Today's webinar will be focusing on grid connection, specifically the connections reform process in the energy sector. My name is Ellie Chenery. I'm a senior solicitor in Burness Paul's energy team, focusing on regulatory matters. I am one of today's speakers, and I am joined by my colleague Tyler McCraw, who is also a member of our energy team. So, before we get started, a bit of housekeeping. Once you have joined, please ensure your mute button has been selected to limit any background noise. Today's webinar won't be interactive, so please do contact Tyler or myself if you have any questions after today's session. Our contact details will also be available at the end of the slides. Today's webinar will be recorded, and if you have any questions on that, please do check out our privacy policy on the Burness Paul website. I'll now pass over to Tyler, who will confirm what is being covered in today's session.
Thanks, Ellie. In today's session, we will primarily be covering connections reform, including the notable Gate 2 process. We will cover in broad terms what connections reform is, why the process was needed, and what the process actually involves. From a practical perspective, which will hopefully be useful for many of you on the call, we will also cover the challenges it presents to developers, both from what we have seen from the past Gate 2 evidence window, but also what we consider to be challenges moving forward for future evidence windows, and lessons that have been learned to date from the Gate 2 application process under this new regime. For now, I will hand back to Ellie, who's going to talk in some more detail about connections reform.
Thank you, Tyler. So what is connections reform? Connections reform is an overhaul by National Energy System Operator, or NESO, to the process by which energy projects connect to the electricity grid. Rather than a first come, first served queue, as has been the case up until this point, the reform has implemented a new manner of connection based on meeting certain criteria in order for projects to progress. So we will delve exactly into the criteria for connections reform a little bit later in this presentation. So why was this needed? Connections reform was needed for a number of reasons, but primarily to fix the current queue backlog. With there being a huge rise in the number of projects in the grid connection queue, this has grown to over 750 gigawatts, which is now more than 4 times the capacity which is needed to meet our clean energy targets for 2030. Also, the first come, first served system. This system was no longer an efficient method for categorising projects. Projects which have been in the queue for longer are not necessarily ready to connect on time due to any number of issues, including planning, regulatory, financing, and/or construction delays. Fundamentally, this system was designed to support a simpler energy market. And given the evolution of the UK's energy sector, the growth in renewables and intermittent generation, the reduction in gas, the growth of EVs, and the demands placed on the system from large industrial users such as data centres, the system was no longer able to handle or prioritise projects in a manner which is consistent with meeting our clean power targets. Also, speculative projects. The current system does not set any specific criteria for connection. Essentially, the project can just be an idea with no land or planning rights. And this means that projects will never potentially make it to these phases, let alone construction, are still given a place in the queue. And that can potentially hold up a project that does have the necessary development rights in place. Also, then, the delay in delivering clean energy. In order to meet the UK's 2030 clean power targets, we need quicker delivery of these projects. Currently, there is a bottleneck created by projects which are stunted and not progressing, and that means that the other projects are not connecting them as fast as we need them to. So rather than working on a first come, first served basis for connections, as I've just mentioned there, the connections reform process has replaced this with a first ready, first connected approach. As part of this process, a gating system has been introduced, and this consists of two gates or hurdles. Firstly, Gate 1, and that's for projects that do not meet the full criteria for Gate 2, and Gate 2, which is for projects that do meet them. So unfortunately, for Gate 1 projects, these projects do not receive a confirmed connection date, location, or queue position. They are just provided with indicative connection details. Gate 2 projects can, however, secure a confirmed connection date, connection point, and queue position, therefore providing more clarity to developers and also placing them in a more favourable position. So moving on to what is the connections reform process and what a project needs in order to qualify for Gate 2. So the criteria for Gate 2 is comprised of two elements. These are the Gate 2 readiness criteria and the Gate 2 strategic alignment criteria. So there is quite a lot of information which has been available on this from NESO, and the criteria is quite extensive and complex. So I'll just be providing an overview on the criteria more generally. So Gate 2 readiness. Gate 2 readiness can be achieved either through what is referred to as the land route or the planning route. Under the land route, in order to qualify for Gate 2, certain land rights need to be secured for the project, and Tyler will cover that in a bit more detail later. Alternatively, a developer can evidence that they meet the Gate 2 readiness criteria through the planning route, which consists of a developer evidencing submission and validation of planning consent for their project. Moving on to the Gate 2 strategic alignment criteria, the second component of Gate 2 eligibility is that a developer needs to evidence that they are strategically aligned. In order to evidence this, they must meet one of the following criteria. Firstly, that they are eligible for relevant protections. These protections cover projects which have a connection date on or before the 31st of December 2026, and that they meet specific queue management milestones. One of the protections is also being deemed a project which is significantly progressed, and this can be evidenced by the project holding a contract for difference or a capacity market contract. The third and final protection is being able to provide evidence of submitting planning application on or before the 20th of December 2024. Secondly, developers can also evidence that their project is aligned to the capacities within the CP30 action plan, which was published by the government. The plan sets out permitted capacity ranges per technology. For example, the plan confirms we should be aiming for 43 to 50 gigawatts of offshore wind. For some specific technologies, the CP30 plan gives regional breakdowns, meaning if a specific area is oversubscribed for onshore wind projects, they potentially will not allocate any more capacity for that technology within that region. Thirdly, a developer can evidence that their project is a project which is covered under the project designation methodology. We anticipate there will be very few projects which seek to achieve strategic alignment through this route, as being a designated project requires engagement and pre-approval with NESO. These projects are projects which are deemed as critical to security of supply, or are projects which would address significant constraint issues on the grid. Finally, a project which is not within the scope of the CP30 action plan, but is instead a specific technology type. As set out in the guidance, there are specific, less developed technologies which can qualify for strategic alignment, and these are technologies like wave, tidal, or geothermal projects. Note, however, before these arrangements are enforced, a one-off exercise has been applied to the existing queue, and this has been called the Gate 2 to whole queue process. This process determines which projects currently hold a connection offer qualify for Gate 2. I'll now hand back to Tyler, who will provide some more detail on the Gate 2 readiness criteria, which developers will require to satisfy going forward when seeking to go down the land route for their Gate 2 applications.
Thanks, Ellie. The last year, and in particular the period from 8th of July to the 26th of August, which is when the first ever Gate 2 evidence window opened and closed, which Ellie will discuss in more detail later, has been a very busy spell for our renewable property team, with developers not just keen to have a steer on their readiness declarations, but fundamentally to ensure that they get their option agreements signed and land rights confirmed in order to secure their place in the grid connection queue. Given the importance to developers in securing land rights for their projects, both as part of the latest Gate 2 evidence window, but also going forward more generally, in this section, we will provide an overview of the Gate 2 readiness criteria for the land route. This is the relevant criteria that developers require to fulfill to evidence having secured land rights for the proposed location of the project, all as more fully set out by NESO in their criteria methodology. As Ellie noted, it is worth acknowledging again that there is a separate planning route which allows developers to satisfy Gate 2 readiness criteria by providing evidence of submission and validation of an application for planning consent for projects following a development consent order process. However, for the purposes of this webinar, we will only be considering the land route, particularly as the DCO process only applies to projects south of the border, and this webinar focuses on Scots law aspects. So in order to demonstrate that land rights have been secured by the developer to lease or own the land, or that the land is already leased or owned for the site on which the project is planned to be located, 3 specific criteria must be satisfied. The first is that the minimum acreage requirements are met. The second is that an original red line boundary for the project is provided. And the third is that evidence of land rights having been secured is shown. Taking each of these in turn, minimum acreage requirements relate to 100% of the land which is required for the project, or in other words, that it is of sufficient size for the purposes of developing the project. The 100% requirement is calculated using an energy density table, which is published by NESO in their guidance document. And this sets out the minimum acreage required per megawatt for different technologies, including onshore wind, energy from waste, BESS, solar PV, and nuclear. For larger projects, which involve multiple technology types being developed on a single site, such as energy parks, NESO will make contact with the developer post-application to better understand the technology mix involved in order to consider the minimum acreage per megawatt required. If the developer fails to provide clarification upon request, NESO will then use the red line boundary, which I will cover in more detail shortly, to assess the minimum acreage per megawatt required and consider all of the relevant technology types listed. NESO's guidance makes clear that the figures included in the energy density table against the different technologies are an indicative guide only. So that means for emerging technologies which may not be included in the energy density table, NESO will assess these on a case-by-case basis after the developer has provided them with the necessary technical documentation. Where an applicant does not believe that they will meet the minimum acreage requirements set out in the energy density table, they can provide evidence via their readiness declaration, being the document to be submitted by developers to NESO in the relevant Gate 2 window, and set out why a reduced minimum acreage is appropriate for their particular project site. Following this, transmission-connected customers may then be contacted by NESO and distribution-connected customers by the relevant DNO or IDNO during the detailed check stage, which for the latest Gate 2 window is currently in progress. The energy density table will be reviewed by NESO on an annual basis so that it takes into account any updates or changes to technology types, as this may ultimately lead to an increase in megawatt per acreage values, particularly with technologies becoming more efficient and innovation within the market. The guidance does provide that there should be industry engagement prior to any amendments being published, so we may well see a growing energy density table for future Gate 2 windows, particularly as the energy sector continues to evolve with new and emerging technologies. The second criteria for developers under the land route is to provide an original red line boundary for the project site. An original red line boundary serves as a new baseline for monitoring a project's compliance with land rights throughout the grid connection process, and is essentially a map which shows the boundary of land of the project that has been secured. The red line boundary does not need to show the project's cable route, the land needed for a substation, or any land used for non-energy purposes. The red line boundary also does not need to match the entire secured land boundary or any planning consent boundary, though it very well might do. The original red line boundary simply needs to be within the secured land right and cover the minimum acreage for the installed capacity. For co-located sites, the original red line boundary can either be a separate red line boundary for each technology or the same original red line boundary for each technology. The latter would be appropriate if it were a solar and wind site, for example, and it hadn't been decided where exactly the wind turbines would be located within the original red line boundary. It would still be necessary to show the installed capacity expressed in whole megawatts or to one decimal place for each technology. NESO has some very other specific requirements when it comes to what information should be included on the original red line boundary. While some of the information appears relatively self-explanatory, such as stating the location and providing a site address and postcode if there is one available, other criteria is a lot more specific, such as including grid coordinates to 3 decimal places. The original red line boundary must also state the installed capacity and minimum land acreage for each technology. The final and perhaps most obvious criteria for the developer to evidence secured land rights for the area which will host the main project. This can be done by a variety of means, including a signed option to take a lease of or to purchase land to deliver the project, by existing land ownership, or via an existing lease. It could also be by a combination of means. So, for example, if there are multiple land parcels involved, it would be sufficient if one of these were to be secured under option and another secured by way of an existing lease. Where a developer seeks to evidence secured land rights by an option agreement, either by evidencing the signed option itself or concluded missives in respect of the option, which makes the relevant documents contractually binding, the option must be exercisable for a period of at least 3 years from the agreement date. Importantly, the agreement date is the date the option is signed and not the date the Gate 2 application is submitted. This is subject to the discretion of NESO though, as there are various exceptions to the 3-year period. Exceptions would include where CPO powers have been granted for all or part of the land which may be acquired, or where the land is subject to confirmation or probate, depending on the relevant jurisdiction. There is also an ongoing compliance requirement for developers to keep the land under option by seeking further agreements or extensions, or keeping or extending the same agreement that's already in place with the relevant landowner until the completion date. The lease or purchase agreement, which accompanies the option agreement, must reflect the typical minimum operational timelines for that type of project. This will be for a minimum of 20 years from the date of exercise of the option. That is unless the developer can demonstrate to the reasonable satisfaction of NESO that the expected operational life of the project is less than 20 years, and that would be most applicable in the context of test and demonstration projects. Alternatively, developers can evidence existing land ownership by providing a copy of the title deeds, which shows that they are the registered proprietor of the land in question, as at the time of submission of the Gate 2 evidence. Finally, where a developer seeks to evidence secured land rights by an existing lease, the lease in question must have a remaining minimum term of 20 years from the date of submission of the Gate 2 evidence. Again, that is unless for a test and demonstration project or a lesser operational life can be justified to NESO. I will now pass back to Ellie, who will provide an overview of the connections reform timeline, including key dates, what stage in the process we are currently at, and what updates can be expected in the not too distant future.
Thank you, Tyler. On the slide, you'll now see the full connections reform timeline, which has been published by NESO. So to cover a few of the important updates so far, in March 2025, we saw NESO publish their key methodology for Gate 2, and that began to give developers an idea of how their projects may be assessed in the Gate 2 process. Then, across May, we saw NESO publish the Readiness Declaration template and the Evidence Submission Handbook, which were two of the key documents essential to making an application for Gate 2. Through to July, we saw the evidence submission window for distribution connected and embedded generation projects open via the Distribution Network First, or DNO. This was then followed by the evidence submission window for transmission connected projects opening via NESO. Developers have had to fill out a readiness declaration for each project, and that provides the relevant DNO or NESO with information on their project, which is then submitted via a portal. The original deadline for submitting evidence was the 29th of July, but we did see this get pushed out by a few weeks to the 26th of August. Supporting our clients through this process has been a particularly busy time for the energy team here at Burness Paull, as developers have been keen to have their readiness declarations reviewed to ensure that they are addressing the questions directly and that there are no errors which would cause NESO or the DNO to reject their application for Gate 2. So where are we at in the process currently, and what updates can we expect to see over the coming months? So in autumn 2025, currently NESO are conducting their detailed checks of evidence that has been submitted. Developers have been asked to be available for questions about their application during this time. In December 2025, notifications will be given to developers with transmission projects no later than the week commencing the 1st of December 2025, where they'll find out if they have passed those detailed checks for Gate 2. Notifications of Gate 1 will also be made no later than this point. Then, in January 2026, we can expect Gate 2 transmission connected projects with connection dates across 2026 and 2027 to be issued then, closely followed by Gate 2 distribution connected projects with connection dates for 2026 and 2027. Then, later in 2026, Gate 2 offers will be issued for the applications up to and including 2030 and the applications for post-2030. I will now pass back to Tyler, who will summarise some of the challenges which developers face as a result of the new connections reform regime.
Thanks, Ellie. The connections reform process has undoubtedly been a busy and stressful period for developers. So, what are the main challenges they have faced and what challenges still lie ahead? Firstly, uncertainty over queue position. Despite the purpose of the reforms process to ensure that projects are viable, strategically aligned with CP30 and set up to proceed efficiently, the latest Gate 2 window and process in general does raise some uncertainty over the queue position of projects. Developers with projects which previously received a connection date, which they were happy with and working towards, are now potentially years out from when originally planned. The implications of that are far-reaching, raising concerns from financial planning to construction and ultimately putting constraints on the overall viability of the project. Secondly, there's the element of unknown. The window over July and August was an unprecedented time for the sector, and it's important to recognise that this was the first time the process has ever been carried out. Whilst detailed application checks are currently still ongoing at NESO's end, developers and their advisors still do not know what approach NESO will take, what queries, if any, they will raise in respect of the applications, and overall, how heavily each readiness declaration will be scrutinised. As the level of scrutiny applied to submitted applications remains to be seen, it is difficult to preempt the results for the latest window, particularly those applications which have complexities that need to be narrated within the readiness declarations itself. Perhaps that's one for a future webinar once there's a better indication as to the kind of approach NESO will be applying going forward for future windows under the new regime. It's also important to flag how this element of unknown applies specifically to parts of the Gate 2 criteria. As Ellie touched on earlier, part of the strategic alignment criteria is if a project is aligned with the capacities of the CP30 action plan. The CP30 action plan sets out how much capacity is needed within the relevant region for a specific technology. If a project is strategically aligned, but there is no capacity left for that technology in that region, this means projects can quickly become oversubscribed, increasing uncertainty around the potential queue position that these projects will be awarded. There is also the issue of costs. The uncertainty around whether a project will be awarded a Gate 2 offer or whether it will slip to Gate 1 results in increased complexities for developers when it comes to planning, budgeting, and financing, particularly from a risk allocation perspective. Developers will inevitably have to incur costs earlier due to the stringent requirements to satisfy Gate 2 readiness criteria, and there are other costs to bear in mind from a technical and legal perspective, with advisors seeking to guide developers through the Gate 2 process. Sums due to landowners under option agreements like option fees, and when these become payable, become far more important considerations for developers due to the reform process. For smaller developers with limited financial backing, the reform process may act as a blocker to the progress of a project, particularly from a cost perspective. For developers and funders, connection risk is now a bigger part of the investment model, as if the connection date is delayed or uncertain, cost modeling, financing, contracting, and procurement, which may have long lead times, are all affected. The last point to mention concerns raising appeals and complaints. In the event initial application checks go unfavorably for developers, they can only raise a formal complaint after receiving the final outcome from the initial checks. If the developer thinks that an error has been made in terms of the process administered by NESO, they can submit a complaint using a standard form, which will be provided once the final decision has been shared. It's important to note, however, that the complaint must be based on an error in how the process was administered and not a disagreement with the overall reform policy. Customers then only have 2 clear working days to raise a complaint. Now, NESO acknowledged that the timeframe might feel condensed, but the rationale for that is that if customers wait longer than 2 days, they may not be able to get them back into the reform process, even if the complaint is upheld. So acting quickly gives NESO the best chance to resolve things if something does go wrong. It's also not unusual to see short timeframes, as we have seen in other regulatory processes. Draw in comparison to the contracts for difference auction process, for example, a non-qualifying applicant only has 5 working days to request NESO to review its decision. In contrast, the CFD appeal process is a 2-tiered system, and so the applicant similarly only has 5 working days to submit an appeal notice to Ofgem after receiving the delivery body's Tier 1 decision. If a developer raises a complaint within the 2 working days of receiving the final initial checks outcome, and the complaint is upheld, NESO will place customers back into the process. If it is not upheld, they will exit the process and can explore other industry routes, such as raising a dispute through the CUSC or other formal channels. These processes can be lengthy and make timely re-entry into the Gate 2 process very unlikely, and it's therefore essential that developers do take note of these timescales for raising complaints and act swiftly in their correspondence and response to NESO at the appropriate time. In terms of some of the relevant considerations that developers should be taking into account as a result of recent regulatory reform, first and foremost, strategizing early and planning appropriately are both key to ensuring the best possible outcome for developers, both for existing and new project agreements. Developers should think ahead and as early as possible about project strategy and viability. They should also plan their finances accordingly and be prepared for upfront spends. We know more than anyone that land agreements, such as option agreements and leases, can take many months to negotiate, agree, and finalize. It's prudent for realistic timescales to be factored into project timelines, particularly to ensure sufficient time for conducting essential due diligence, all with the intention of ensuring that land rights are secured early and underlying property documentation finalized well before the desired window. It's also important for developers to ensure that all necessary consents, planning or otherwise, are obtained and key milestones and deliverables achieved, whilst ensuring that supply chain plans are put in place as early as possible. Up until now, NESO has produced a comprehensive guidance document hosted a webinar series, and produced various Q&A sessions. But the fact that uncertainty still remains over the process shows that there is a lot more to be done in this area. It's important for developers to understand the criteria and what's required of them, the guidance documents that are available to them, and the process in general, whilst ensuring to closely monitor timelines and any updates from NESO directly. I'll now pass back to Ellie, who will summarise some of the lessons that have been learned to date from the Gate 2 application process under the new regime.
Thank you, Tyler. So moving on to lessons learned, whilst the industry is generally supportive of the purpose of connection reform, it is clear from the recent Gate 2 window and the application process that this process is not without its flaws, and there will be more issues which undoubtedly arise once developers begin to hear back about their queue position. So far, some of our lessons have been, firstly, with regards to the portal. For example, when the Gate 2 window opened, it soon became clear that the NESO portal had some technical issues, which ultimately prevented users from submitting their applications for the window. Issues ranged from incorrect validation, file upload problems, and confusing mandatory fields, all of which resulted in delays. In addition, several questions were viewed as unclear or difficult to interpret, and then by the 25th of July, NESO had received over 2,600 queries, all from portal users that were having issues. Obviously, NESO's remedy to fix this issue was to extend the Gate 2 application window, and that gave them time to fix the portal's functionality and also improve its customer support before the new deadline. However, it remains to be seen whether this is an issue which will affect future windows or if other technical issues will surface instead. Therefore, ensuring from NESO's end that they have a portal fit for purpose and use is essential, and for developers to make sure they are prompt in their applications so that any issues do not need to be flagged to NESO at the last minute. Moving on to legal. Whilst we have acknowledged there is an element of unknown with the connections reform process, it is important to remember that NESO are not lawyers. They don't have Scots law qualified real estate lawyers in the background or simply the resources to analyse in depth the massive documentation that is presented to them off the back of the latest Gate 2 window. The underlying property documentation can often be complex in nature, particularly where conditionality applies to the option or missives and underpins the basis on which matters have become binding. So, developers should bear this in mind when preparing future applications, as any ambiguity in readiness declarations should be minimised where possible, and careful consideration should be given to the content and in particular the accuracy of terms, whilst ensuring to comply with NESO's guidance and the readiness criteria. A lesson learned was also with regard to the timing of the CFD allocation round 7 window and the evidence submission window under Gate 2. Developers who bid for AR7 were required to have a firm sense of their grid connection timings, as these have a knock-on impact on their CFD bid assumptions. Therefore, for future applications for both Gate 2 and for CFD, developers should ensure that as far as possible they have the information needed to participate in both of the application processes, and they should plan ahead for this. Undoubtedly, this will also need to be something factored in by NESO, as it should be recognised that if Gate 2 offers are not confirmed at a specific point, that this can cause delay to developers in delaying their bid or deciding not to bid at all. Finally, it is also important to check specific DNO guidance. As mentioned earlier, there are slight variations to the timelines for distribution connected projects that are with the DNOs compared to transmission projects that are with NESO. As a result of this, there are different challenges which presented themselves depending on which portal that a developer was using. An example of variation approach is that for one DNO, specific documents needed to be submitted via email rather than through a portal. As such, it is important that developers familiarise themselves with any deviation in processes across the DNOs and NESO. That now brings us to the end of today's session, but if you'd like to hear more about any of the topics covered today, or if you have any specific queries for us, please do reach out to one of the team and we'd be delighted to hear from you. As discussed, our session today has been recorded and you will receive an email with a link to the recording of the session, and that will be early next week. In that email, you will also find a link to register to future sessions and learn more about the programme. So please do use the link to these upcoming sessions and book your spots in advance. Our next session is on Thursday, the 20th of November, and that will focus on warranty and indemnity insurance. Thank you very much for joining today's webinar, and we look forward to seeing you at our further sessions.